Hello everyone, welcome back to my YouTube channel Legal World. Myself Dr. Seema Goyal. As in the series of company law, I have discussed certain important questions relating to the company law. Today in this video, I am going to discuss one more important question relating to the company law. My question is, define the term article of association and what does the article of association contains and what are the contents of article of association, and also define the relationship as well as the difference between the article of association and the memorandum of association. This is my question. If we talk about the article of association, that is described in the section 2 clause 5 of the Companies Act. As per section 2 clause 5, article means article of association of the company. As per section 5, the article of the company shall contain the regulations for the management of the company. As per section 5, the article of the association of the company shall contain the regulations for the management of the company. Thus, the article of association are the rules and regulations for the internal management of the company, and they are framed to carry out the aims and objectives as set out in the memorandum. The article defines the duties, the rights and the powers of the governing body between themselves and the company at large, and the mode and the form in which business of the company is to be carried on. And changing in the internal regulations of the company may be made from time to time, and the members shall have full control over the article and may alter them according to what they think, and the articles are subordinate to the memorandum. If we talk about the article of association, that should be inconsistent. If we talk about the article of association, that must not be inconsistent with the memorandum of the Companies Act. The article must be printed, that must be divided into the paragraphs and consequently numbered. So the article should not be properly stamped and signed by each subscriber to the memorandum in the presence of witnesses. They are to be filed with the registrar along with the memorandum. A company having the share capital is free to file its own article as given in table F of the schedule. And a private company, a company limited by guarantee or unlimited company must file their own article as given in table G of the schedule 1. If we talk about the matters which are specified in the article of association or the contents of article should not contain anything which is against the Companies Act, the memorandum of the company, and any other law for the time being in force. Thus, we can say that the article contains, number 1, the share capital and the variation of rights. Second one is lien of sharers. Third one is calls on the shares and forfeiture of shares. Fourth one is transfer and transmission of shares. Transfers and transmission of shares. Next is alteration of the share capital. Next is capitalization of the profits. And the next one is buyback of shares. And the lastly, general meetings, proceedings or the general meetings and adjournment of the meetings. Next one is general meetings, proceedings of the general meetings as well as adjournment of meetings. That is also contained in the article. And the next one is voting rights and proxy. Next is board of directors and proceedings of the board. And chief executive officers, managers, company secretary and the chief financial officers are also contained in article. And the next one is the sale, the dividends, reserve and accounts, winding up, indemnity. These are all contained in article of association of the company. As per section 5, the article of association of a company shall contain the regulations for the management of the company. Second one is, it shall contain such matters as may be prescribed. And the article may also contain the provisions for the retrenchment. And the next one is, where the article contains the provisions for the retrenchment, whether made or formation of the or by amendment of the company, shall give the notice to the registrar of the such provisions in the manner prescribed. The article of the company shall be in respective forms as specified in table F, G, H and I and J in Schedule 1 as may be applicable to such company. Section 6 of the Companies Act provides that any provisions in the memorandum, article, agreement or resolution shall to the extent to which it is repugnant to the provisions of this act becomes void as the case may be. The article of the association can be altered by passing a special resolution. And if an act that is ultra vires the memorandum, that is absolutely void. If we talk about the relationship between the memorandum and article, there are the certain relationship between these two. And the first relationship, that is the articles are subsidiary to the memorandum. In the Asbury Railway Carriage Company versus Ritchie, the Lord Cairns has held that the article plays an important subsidiary role. If we talk about the relationship between the article and memorandum, there is certain relationship between these two. First is articles are subsidiary to the memorandum. In the Asbury Railway Carriage Company versus Ritchie, in 1875, Lord Cairns has held that the article plays a part that is subsidiary to the memorandum of the company. They accepted the memorandum as a charter of the incorporation of the company, and the article proceeds to define the duties, rights and powers of the governing body as between themselves as well as the companies at large. Article also defines the mode and the form in which the business of the company is to be carried on, and the mode and the form in which changes in the internal regulations of the company may from time to time be made. Articles are subsidiary to the memorandum, as the memorandum contains the fundamental conditions upon which alone the company is allowed to be incorporated, while the articles are internal regulations of the company. So we can say that article is subsidiary to the memorandum. And the second one is the memorandum and article must be read together, but the terms of the memorandum cannot be modified or controlled by the article. And if relationship between these two, that is the powers of alteration of the article is subject to what is prohibited by the memorandum, expressly and impliedly. These were the certain relationship between the memorandum and article. But if we talk about the difference between these two, the first difference, that is regarding the meaning. The memorandum of the company, that is the charter of the company, and it contains the fundamental conditions upon which the company is allowed to be incorporated. On the other hand, articles are the internal regulations of the company. And the second difference, that is regarding the purpose. Memorandum defines the object of the activities of the company, while the articles are the rules for carrying out the objects of the company as set out in the memorandum. Thus, the articles are subsidiary to the memorandum. And the third difference, that is regarding the alteration. Articles can be altered by passing the special resolution unless it has retrenchment clause, while the alteration in the memorandum in certain cases requires the approval of the central government or the tribunal or the court also. And the next difference, that is regarding the ratification. Any act which ultraviolates the memorandum of the company, that is void and cannot be ratified even by whole of the body of the shareholders. While on the other hand, anything done by a company in contravention of the article is only irregular and can be confirmed by the shareholders. If we talk about the form and signature of the article are to be printed, must be divided into paragraphs, that is numbered consequently, and must be signed by each of the subscribers of the memorandum, who shall add his name, description of the occupation, and it should be signed in the presence of at least one witness, who shall at least the signature by adding their address, description and occupation if any. If we talk about the alteration in the article, it can be done by certain modes. First, by passing the special resolution. According to Section 14 of the Company Act, alteration in the article can be made by the special resolution. Second one is alteration must not be inconsistent with the provisions of the Companies Act or any other law in force or the memorandum of the company. Third one is alteration must not be illegal. Article cannot be altered to empower the company to do any act which is illegal, unlawful, or against the public policy. So a company cannot alter its article to run the law outrage. And the next one is alteration with the approval of the central government or the tribunal or the court. In certain cases, alteration will be effective only after the approval of the central government or tribunal or the court. For example, according to section 14, alteration of the article which converts the public company into a private company shall not be effective unless it has been approved by the tribunal. Next one is alteration cannot impose burden to buy more shares. Next is alteration must be bona fide for the benefit of the company. And the alteration must not constitute the fraud or the mindset. And then alteration must not result in the breach of contract with any person. This was all about the alteration of the article. And this was question relating to the article of association. And this is one of the most important question for the examination point of view. And if you have any doubt, you must put down in the comment section. And don't forget to like, share and subscribe this channel for the further update. Thank you.